So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today, we're going across the pond to talk about HR over there in England, where removing a female staff from WhatsApp groups while they're out on maternity leave is considered discrimination. This comes from the Daily Mail, so do take this with a grain of salt. They're, famously unreliable. But Asha Ladd was removed from her work's WhatsApp account while they were out on maternity leave, and that caused a bit of a problem. Asha worked at a pretty small Birmingham dental office called Lilyhead Dental Practice Sales Limited back in 2018. I say it was Birmingham, it was actually Warwickshire. And they only have like 10 employees and they sell dental practices to potential buyers. And she had a cell phone through the company. In January of 2021, she went out on maternity leave and was presumably on WhatsApp sharing information. In July, while on the second period, she lost the phone and was looking for a replacement SIM card so she could access company systems. And the company didn't provide her a work phone. And she was upset. She sent an email to the manager saying, "I remain upset regarding initial emails denying access to data on my work phone." Now, for clarity's sake, WhatsApp is a messaging app. I believe it's owned by Facebook still. That is mostly used overseas. Most Americans do not use WhatsApp, but it is something that's pretty common overseas, similar to Facebook chat or any of the other chatting apps. It is so these they were chatting back and forth. She lost her phone, and the company just decided not to replace it. She actually filed claims on race discrimination, pregnancy discrimination, victimization, and unauthorized wage deductions, but those were all dismissed. Only the maternity discrimination was ultimately upheld by the employment tribunal. So we got to talk about these employment tribunals. The industrial courts first came out in the early 20th century, and it was marked the initial efforts to address labor disputes and conflicts in the workplace. The idea was to resolve collective industrial relations issues, and it was seen as a precursor to the modern employment tribunal system. Then, in the Industrial Relations Act of 1971, they started industrial tribunals in the United Kingdom. The tribunals were created to hear individual and collective employment disputes, including unfair dismissals and trade union related matters. That led to the foundation of the Advisory, Conciliation, and Arbitration Service. Then, from the Employment Protection Act of 1975 in England, there was the expanded jurisdiction of the industrial tribunals and introduced additional employment rights. It was pivotal in shaping the modern employment tribunal system. Further from this came the Employment Tribunals Act of 1996, which consolidated and modernized the statutory framework for employment tribunals. This act clarified the jurisdiction, powers, and procedures of the tribunals and established a more unified system for handling employment disputes. Then there came tribunal reforms in the 2000s with the Employment Act of 2002, which promoted conciliation and ADR, or alternative dispute resolution methods, with the aims of resolving disputes before they reach the tribunal stage. The Enterprise and Regulatory Reform Act of 2013 made significant changes, which introduced mandatory early conciliation through ACAS before a claimant could bring a case to tribunal. And then from 2013 to 2017, there was an introduction of tribunal fees that led to a period of controversy and legal challenges. Claimants were required to pay fees to bring their cases to the tribunal, but was ultimately deemed unlawful by the Supreme Court. Before Asha got here, she had the option of doing an ACAS early conciliation. It's a voluntary service where the conciliator attempts to facilitate a settlement between the parties. If it doesn't work, she can submit a claim to the employment tribunal and then get a response from the employer. And then a case management discussion, which it's where the employment tribunal schedules a case management discussion to clarify the issues, identify key points of dispute, and explore possibilities for settlement. These discussions help move things along. They streamline the proceedings. Then there's a pre-hearing review, an exchange of documents, and ultimately the hearing after witness statements. So she went through quite a bit of work to fight for her right to WhatsApp. Now, an interesting note and kind of a point on this channel is to do comparisons between one country and the United States in specific. In the United States, WhatsApp or any other workplace communication device would actually be discontinued because there is the potential of FMLA interference. And so, quite frequently, if you go out on FMLA, the company might shut off your computer access and your communication access to the rest of the company, and that's because they don't want you working while you're on FMLA. It can lead to FMLA interference and can lead to big fines for the company. And so that's the interesting thing when we're comparing the United States and these other countries. This was appeared to be a right to be involved in the WhatsApp chat even while off of work. It made her feel isolated. What do you think? Should this be against the law in the United States? Should you be removed from WhatsApp chat or Facebook app? When you're having these discussions in the workplace. Let me know what you think about this ruling in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.